All right, I had prepared some questions, but I think I'm going to dispense with those in the interest of time so that we can get to your questions. But before we do that, let me give the panelists an opportunity to respond to one another. There were some gauntlets thrown. And so I want to give you that opportunity before we have student questions.
Can I go first?
Sure, go right ahead.
Let me just say that my own comments to one side, this was like a remarkable panel. I really enjoyed all of my co-panelist presentations. There was only one really bad moment in the whole thing.
When could that have been?
And that is when Lino invited us to imagine the Supreme Court naked. It's going to take me days to get over that. I may never get over that, and it's certainly going to ruin my lunch. All right, so I'm going to be very brief. I'm just going to suggest that most of what the courts do is constitutional construction. I think, and most of my comments here are going to be a response to Lino. Most of what the courts do is constitutional construction. If that's true, then most of what they do is not interpret the Constitution, and that's true, and I believe it's also inevitable, no matter what kind of judicial system that you have. But where the Constitution does speak, I think it's incumbent upon the government to respect what it says. So if the Constitution says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, that is in the Constitution. That phrase has a meaning. Now I realize that meaning is somewhat vague in its application. It's not automatically clear what the privileges or immunities of citizens of the United States are, but this is an injunction both on the states, and it's also an authorization for, under Section 5 of the 14th Amendment, for the Congress to enforce this provision. So even if you adopt Lino's rule of construction that says where something is vague or it's not clear, something is not clearly prohibited to the states or is not clearly prohibited to Congress, then it's up to the what Judge Randolph described as the democratic process to decide by means of either in Congress or the states. Even if you adopt that view, if those folks are supposed to follow the Constitution, they must give meaning to the privileges or immunities clause. They can't simply ignore it. At least not if you're going to be an originalist. So here is where I think originalism comes in and has bite again. Even an originalist who believes that clause is vague and therefore believes the judges should stay out of it, which I am obviously not one of those people, but even if you did believe that, unless you think that Congress and the states are free to ignore what the Constitution does say, its original meaning, then someone's got to give meaning to that vague clause. And you can't just punt and say, forget about it, which is exactly what's happened in the last 135 years since 1873. The court and then Congress and then the states have basically said, forget about it. And that can't be consistent with the original meaning of what the Constitution does say. And just two little teeny points. One is that I think it's a fiction to equate the legislature with the people, which is something that is commonly done when one wants to defer, when one argues in favor of rule of construction of deference. The legislature in Congress is 535, or however many there are, men and women. They are not the people, and if anyone was under the illusion that they were the people, this recent debate over the constitutionality of health care or the appropriateness, the policy appropriateness of adopting health care should disillusion you of that fact. They are themselves, and it's a fiction to think they're other than that, and they are subject to the Constitution. And the last thing I will say, just about historians, because I do have a high regard for historians, and I think Judge Randolph is probably a better historian than many historians are, because he understands these fallacies. I just would not take on faith what a historian tells me about the meaning of the Constitution. Historians, in fact, do take individual snippets of evidence and individual historians do take individual snippets of evidence and line them up to reach a particular conclusion. And we might call this history office law. Historians do practice history office law, and even a non-historian can sometimes detect when they've done so and establish that they have done so. So I have a lot of respect for historians. I have a great respect for the historical method done properly, but it isn't always done properly by people who have PhDs from history departments.
Professor Nelson.
In the interest of time, I'll just make offer two quick thoughts. One with respect to Professor Roosevelt's very interesting presentation. The second part of the presentation with respect to prophylactic rules and so forth, I take to be, in the interest of adding yet more subtle distinctions into the discussion, I take to be about a slightly different thing than the ascription of meaning to the Constitution itself, right? It's about how to implement the meaning that we ascribe to the Constitution, and in particular about how courts implement the meaning that they ascribe to the Constitution, which means that we've got the interpretation-construction distinction with respect to the meaning that we ascribe to the Constitution, and then we've got a further level of distinction about implementation, and the two are different things, just to be clear about that distinction. With respect to Professor Graglia's comments, I have only two thoughts. One, in order to know that the court is making stuff up, you need to interpret the Constitution, and when you interpret the Constitution, you will occasionally come across indeterminacies both at the rule level and at the application level. Just as a citizen, you need to figure out how to respond to ambiguities or vagueness. And even if one did away with judicial review entirely, you would still face the interpretation construction question, right? Even if we had no judicial review, a conscientious legislator trying to conform to the Constitution would need to figure out how to handle indeterminacies in the Constitution. I don't actually take the Thayerian principle of judicial review that Judge Randolph talked about to be a real construction of the Constitution. I don't think the Thayerian judicial review idea is built into the meaning of the Constitution. I think it's a principle that operates independently of meaning. It's about judicial review, not about constitutional interpretation. So that's yet a fourth, I guess, highly refined distinction to throw in, but I'll stop there.
Professor Roosevelt.
Well, in the interest of time, I think maybe I'll say only one thing. I would like to adopt, I guess, most of what Randy and Caleb have said. I would also say I think that this is very common in law school and to some extent in the academy generally. It's that we get a very distorted picture of the way the Constitution works in society if we focus just on Supreme Court cases, because those are the hard, the controversial cases. So, to the extent that you think judicial review is just politics based on your sample of particular ideologically inflected Supreme Court cases, it might look that way there, right? But if you take a much larger sample, if you think about the cases that never make it to the Supreme Court, and even the cases that are never brought because the outcome is so clear, the Constitution might look a little bit less like a mask for policy decisions.
Professor Graglia.
There really is no uncertainty or difficulty about the 14th Amendment, this privileged immunities that Randy finds to be the justification. The 14th Amendment very clearly was adopted because Congress passed the Basic Civil Rights Act 1866, which gave blacks basic civil rights, right to make contracts and own property, basically. Andrew Johnson, the president, vetoed it. They passed the 14th Amendment in order simply to constitutionalize that. And they was insisted in its ratification. It never was properly ratified. Of course, it was coerced by the states. But putting that aside, it was insisted that in the North that, look, all this does is protects blacks. It'll have no application in New York. It'll have no application in Massachusetts. There's no reason states would have ratified something that says, well, from now on, what is a privilege and immunity and what we can and cannot do will depend on the Supreme Court. That's not a sensible, you can only come up with that. You have to be driven to do that, and Randy is driven to do that because his faith in democracy, like Brennan's, is very limited. He tells us does Congress really represent the people? Wow, no.
They are not the people, that's all I say.
Congress doesn't really represent its own, but it's better than relying on Harry Blackmun. That's all I have to say about that. Professor Caleb says, well, without judicial review, you still have to interpret the Constitution. The legislature says, well, sure, let them interpret it. I happen to be, perhaps surprisingly enough, a believer in the living Constitution, as long as it's Congress that makes it live. It makes it live by reducing and removing restraints, which are bad ideas. Brennan made it live by adding restraints, by precluding new policy choices. But when Congress relaxes it, Congress has relaxed it so the Commerce Clause now can regulate everything. Well, apparently that's what the people want. They keep electing Roosevelt, did they not? We have a more normal system. All federalism is, Congress can do anything, but has to do it in a sneaky way. That's the American way, right? Can Congress prohibit race discrimination like any other nation can? No, but Congress can regulate interstate commerce. That's what we're doing. Come on, we should be ashamed of that. Finally, as to Judge Randolph, I must say, I'm shocked by his criticism of the court, saying that they made every possible legal and factual error. It's enough to shake my faith. I wonder how he discovered that. Gee, you know, he started out by saying, but he said the Supreme Court couldn't possibly do this. He knew that. I said, where have you been, Judge? You're not paying attention. They can do anything, and you just got another example. I give you better examples and more examples. You know, Jackson said we're not final because we're infallible. We're infallible because we're final. And that's the case. They can't do that. They can do anything. You know, there's a statute that says that desegregation means assignment without regard to race. And then it goes on redundantly say it does not mean busing for transportation for racial integration. And then it says it 2 more times. I think if you say it enough, Brennan will believe it. But it won't. And they immediately hold that, you can bus kids for racial balance. Compared to his little example, that's nothing, you know.
I hate to cut off this stream of consciousness, but we do need to get a few
And that was such a good
questions in.
job that they named the federal courthouse in Louisiana after the judge who did that.
Thank you.